Welcome back. Attorney Andrew Bethel of Bethel Law, where we talk estate planning, finances, real estate, and taxes. For today's video, we're going to take things back to basics, the correct way to execute your will in California. Whether you're just starting your estate plan or updating existing documents, understanding this process is vital. So hit the like button, subscribe, share the video with someone you love, and let's dive in. First, let's talk about witnesses. When you execute a document like a will outside of my office or any lawyer's office really, it's crucial to get the execution requirements of your estate planning documents correct, especially when it comes to signing your last will and testament. This may seem straightforward, but it's a common area where mistakes happen. Unlike other documents like trust or powers of attorney, a California will requires 2 witnesses, not a notary. Why is that important? Let's find out. Witnesses have 2 main roles. First, they ensure that you, the testator, that is the person making the will, has the mental ability to create a last will and testament. This mental ability is called testamentary capacity and includes understanding the nature of the will, recognizing beneficiaries, knowing your assets, and the implications of your decision. Secondly, witnesses help prove that the will is made without any fraud, coercion, or undue influence. In essence, they ensure that the will truly reflects your wishes. So, who can be a witness? In California, you need 2 disinterested witnesses. This means they should not have a financial stake in your will called a pecuniary interest. Typically, beneficiaries of your will or anyone who stands to gain from it cannot be witnesses. Notably, there are exceptions like an attorney who drafts the will, relatives of beneficiaries, creditors of beneficiaries, takers under an anti-lapse statute, or most importantly, to keep in mind and likely the most common choice after the drafting attorney, nominated executors. But the general rule is to choose someone who's not named in the will. Speaking of executors, let's clarify their role. An executor is someone you nominate to manage your estate after you pass away. They handle everything from paying debts to distributing assets to the beneficiaries. Additionally, although they can request a fee for this service, their primary duty is to act in the best interest of your estate and the beneficiaries. They're usually not considered to have a financial interest in the will unless they're also a beneficiary. However, as a general rule, my recommendation is that if someone's name appears in the will for any reason, then don't let them sign as a witness. Don't let them get into your last will and testament with a pen. That's just asking for trouble. To sum up, when executing your will, consider having your attorney or someone wholly unrelated to the will as a witness. This safeguards your estate and ensures your wishes are followed. Remember, your witnesses don't need to know the contents of your will. They just need to know that they are witnessing your last will and testament. If you had someone witness your will, and as it turns out, they do have a pecuniary interest in your will, as in they're a beneficiary, then the court is going to presume that their name is on there due to some type of fraud or undue influence. Thus, that person's gift, whatever they would receive under the will, is just going to be cut out of the will entirely. Now, they might be an heir of you already, like a child, but that's still going to create a whole lot of complications, a whole lot of explaining, and running the risk that the court is going to invalidate their bequest through your will in the first place. So again, just pick somebody who's not in the will at all and have them be your witness. Executing a will correctly is a critical step in securing your legacy and protecting your loved ones. Overcoming deficiencies in wills is always a headache for not only me, but the judge and most importantly, the family. I've seen some weird stuff in people's wills, I have some interesting stories. In fact, if that's something you'd like to hear, then let me know in the comments below. Do you have any other questions or video topics? Drop a comment below. I'm attorney Andrew Bethel. Like, subscribe, share the video with a friend or family member, and I'll see you next time.